Inside the Beltway. My guest is Senator Mike Lee, whose brand new book, Saving Nine, is in my hands, and I have read it. We're going to talk about it. Good morning, Senator. Good to have you back.
Good morning, Hugh. Great to be with you as always.
I want to begin by reminding new audiences in Portland, Maine, and New Hampshire, and a few other places that in 1984 and 1985, I was honored to be a special assistant to first Bill Smith and then Ed Meese. And that meant I got to go to the Friday morning all hands meeting in the AG conference room when then Solicitor General Rex Lee would at least once a month stand up and brief on the Supreme Court. And I learned the famous rule: first thing you got to remember, count to five. You recount having a father who's a Solicitor General in Saving Nine. Can you start with what that impressed upon you from an early age?
Sure. Look, because my dad was Solicitor General of the United States, he was arguing as the Reagan administration's chief advocate before the Supreme Court of the United States. I didn't really know what that entailed. All I figured out quickly was that at the age of 10, if I told my parents I wanted to go to court with my dad, I could miss school for a few hours. But at first it was strange. It was unusual. It was like church in a foreign language. You had to hold still and be quiet. But I learned to appreciate the rhythm of the court, even when I didn't entirely understand what was being said. And I developed a deep reverence for this institution. I came to understand this is a different place. It operates differently than a political body, and it's always to be respected, even when you disagree with its outcomes. And over time, I came to realize that this is pretty key to the functioning of our constitutional republic. We've got to have an appreciation for the court of the fact that it's not a political body. It's something special.
Now, Saving Nine is, for me, a bit of a review because I teach con law every year, but I get 40 weeks to teach it, and I don't have to jam into one segment or two. You're going to be with me two segments, the key parts. But I do appreciate the succinctness with which you explained how the court went from six all the way up to 10 and settled at nine. And the dates are 1862, 1866, and 1869. Would you run through that for people to understand? Because this is very important to your argument about stability.
Yeah, so I talked about this in Chapter 2 of Saving Nine. I explained how we got to the number nine. And, we've had five justices. We've had six. It's gone back to five. It's gone up to seven. And this most recent wave occurred in 1862, 1863. And finally, by 1869, we had gone from 7 to 8 to 9 to 10. We finally went back to 9 in 1869. And so for more than a century and a half, more than 150 years, the number 9 has persisted and it's worked. As I explained in Chapter 2, there really is nothing magic about the number 9. The number 9, for the number of justices on the court, it's not written into the Constitution. They could have opted for a different number. The reason we stick with it now, the reason we must stick with it, is because this is where the court has operated for a century and a half. And during that time period, the court has waded into some territory that's gotten more controversial. So any step we take further in that direction, where you've got, let's say, a court that is being expanded, not because of an inadequate workforce, not because of a human resources problem within the court, but when you've got an attempt to expand it to bring the court to heel to the president's political ideology, that's where the problem lies.
Now, Senator Lee, I don't want people to think this is your argument. You're running for re-election. You're going to win handily the primary. I've endorsed you. Everyone who listens to this show knows you're going to win in Utah, and we're on in Salt Lake City right now. This is not your argument. It's my argument. Although the 14th Amendment was ratified in 1868, I think there's a pretty good argument that our understanding of due process prohibits changing the number of the court now after 150 years at 9, because it would violate our fundamental understanding of fair and due process owed litigants, that the law can't be changed by a passing majority after 150 years. That's my argument. You don't make that. You make a political argument that it's just fundamentally destabilizing. I think your argument is persuasive, but I just want to remind people there's a constitutional argument out there that Senator Lee does not make, but that I do.
Yeah, so that's an interesting point. Let's explore that for a minute. So your point would be that you can't have due process that's due that the people are entitled to under the Fifth and 14th Amendments would then prohibit the number from changing because that would itself deprive them of the fundamental fairness of an objective, impartial, independent court system. Is that the point?
That's it. And that a predictable change occurs at the court over time. And we know, constitutional amendment is a different category. And we know what to expect from a court with precedents that bind unless they are bad. And we don't want, due process does not envision radical changes brought about by political actors like Brian Fallon pursuing outrageous radical changes in the court because they don't like the result of elections.
Yeah, no, that's an interesting theory because we're talking here. You're saying that changed with the adoption of the 14th Amendment. Prior to that, they could have done it. Subsequent to the 14th Amendment, you believe they couldn't?
But not immediately, because the 14th Amendment isn't ratified before the last change of the court up to 9 in 1869. But I believe over 150 years, as you point out, we are now used to 9. We count on 9, and we count on the process of confirming judges and debating judges and stare decisis and over. We all believe in the rule of law, and when you throw a spanner in there, like let's pack the court, that you are violating the due process, the fundamental understanding of fair play in American courts. I think that's what's at risk here.
Right. That's an interesting point. Now, the 14th Amendment itself is applicable to the states and not to the federal government.
Correct.
The Fifth Amendment due process clause was in effect already at the time. So would it have been your position that once the Fifth Amendment had been ratified, that would likewise have been unconstitutional?
No. My position is that after the 14th Amendment came through, the United States expanded the reach of the court, but they also began to settle into how the court operated. I think you did a very good job of pointing out the early court, the first 3 justices followed by Justice Marshall. They didn't really know how to run it. They did their opinion seriatim. There was lots of change until the institution settled down. But after the upheaval of the Civil War and the 14th Amendment, the country settled into an understanding of federalism and what the 14th Amendment was that was marred by Jim Crow that had to be reversed in Brown v. Board, but that generally we have understood for more than 150 years. The court stands for the rule of law that changes only in the constitutional amendment or very slowly as the court changes, not radically by political action.
Right. And that is fundamentally the problem with court packing, is that they want to change the court radically. They want to change it not organically in the way that it's supposed to change, meaning when someone dies or resigns or, heaven forbid, someone is impeached and removed from the court, then there's a vacancy. Once that vacancy happens, then the incumbent president has the opportunity to nominate a replacement. And if and when Congress the Senate, rather, is able to or inclined to confirm that nominee, then the change happens. But without those ingredients, you're not supposed to have change within the court's composition, and so you don't.
And when the court goes radical, as Dred Scott went radical, in 1863, Lincoln declares a new birth of freedom. In 1868, we passed the 14th. 1868, we ratify the 14th Amendment. We start over as a country healed of our original sin, and that is the Supreme Court is at the center of that. And I really appreciate Saving 9, Senator Lee, because you're making an argument with some pretty radical people, and they just showed up and they took over the Democratic Party. And I don't care if they got 6 Harvard law professors as opposed to 2 aging and out of touch law professors. To agree with Brian Fallon, they are proposing fundamentally destabilizing the United States. And you make that argument very well in Saving 9.
Well, thank you. And I go out of my way to point out that this has been overwhelming consensus within the United States. Left, right, center, libertarian, socialist, everyone for our lifetimes, basically the entirety of the time you and I have been alive, it has been bipartisan consensus in this country that court packing is bad. And all of a sudden, look, 2.5 years ago, I would never have dreamed that this would become a mainstream idea again, or that it would be something that somebody could bring up and be taken credibly. But as I explained in Saving Nine, started worrying about this during that first presidential debate between Joe Biden and Donald Trump when it was brought up, and
Joe
Biden
Biden wouldn't answer.
denied.
We're going to come right back with Senator Mike Lee, who's going to win re-election in Utah. So he's got another 6 years ahead of him in the United States Senate, fighting against very effectively from his perch on the Judiciary Committee, packing the court and destroying fundamental fair due process. Saving Nine is in my hands. I've read it over the last 3 days. It is a great summary for a layman on what is going on about packing the Supreme Court. And there are names in here like Brian Fallon and Paige Herwig, which you need to know about. But more importantly, and I just want to give you the floor for 4 minutes, Senator, this movement is run by the hard left. It's financed by the hard left. And Justice Alito and his question in Citizens United opened the door to the hard left's dark money. But when Sheldon Whitehouse starts talking about dark money and doesn't bring up the hard left trying to buy the court via court packing, it drives me crazy. How do you talk to someone like Sheldon Whitehouse when the hypocrisy is so sky high in the room?
It's one thing for him to leave out serious vulnerabilities on his side of the aisle. It is quite another to listen to him delegitimize the Supreme Court of the United States, delegitimize another branch of government, a branch that's known for its objectivity, a branch that, despite its flaws, warts and all, is the best of its kind anywhere in the world.
In history.
It's very hard to
in
listen
history.
to.
Yeah.
In history. And, frankly, Hugh, it's one of the things that has given the United States of America its strength. The fact that we've got an independent judiciary, the fact that it protects the rights of the individual, the fact that it really is willing to stand up to power and able to do that because of our constitutional structure. To hear a lawyer, an attorney, counselor, and officer of the court, which he is, stand up and delegitimize the court is something very foreign to me. And frankly, it's anathema to our constitutional form of government. And it's one of the reasons why I decided to write Saving Nine, is because I saw so many of my colleagues start to try to delegitimize the court. This is a precursor. This is what they do before they start to pack it. That's
Saving Nine
is when I decided to write this. I knew I had to do it.
Saving Nine is available in bookstores at Amazon. I have tweeted out Saving Nine. Don't forget Saving Nine. Go and get it. Mike Lee has got to run for office, so he can't really go out on a book tour, but I can tell people to get Saving Nine. I just want to know if you agree with me. You and I will go to our rewards. And 100 years from now, if the Supreme Court is not at 9, the Republic will have failed. I believe that because the rule of law is so closely intertwined with stability, predictability, and the functioning of the court that if you take away that pillar, I just want to know if any Democrats that talk to you sidebar understand that.
I think they do. I think a number of them do understand it and do respect it. But here's what worries me, Hugh, and as I describe in chapters 7 and 8 of Saving Nine, it's of deep concern that when Franklin D. Roosevelt's court packing plan was moving through Congress, you had Democrats who were openly doubtful of it.
Yes.
You had Democrats who were coming out in opposition to it. You don't have that today. And while I believe that not every Democrat feels that way today, not every Democrat supports the idea of packing, and some of them see the risk to it. You're not hearing it. You're not hearing it from them. They're not expressing doubt, and that really, really worries me. Because
you're right. You're right. You're absolutely right. Chesa Boudin got tossed out in San Francisco last night. That is a rejection of the progressive left, but the rest of the Democratic Party are cowards on this issue. They need to stand up for the court.
Right. Exactly. And the reason I felt so compelled to write Saving Nine is that without this 9-member court and the objectivity and independence of the court, this thing is all over. And as I explained in Saving Nine, this is not, if at any moment the Democrats in the Senate decided to nuke the filibuster, which literally could happen at any moment, if Manchin and Sinema changed their minds about nuking it, even just for this one instance, this is an action that they could take that could pull up the linchpin in the Constitution, the keystone, the cornerstone. The whole thing collapses without the independence of the judiciary, something they could do by statute. That should worry every one of us.
Amen. Mike Lee, thank you for writing Saving Nine. Good luck in your primary and general election. I think you'll coast in both, but nevertheless, I appreciate your taking the time to write Saving Nine because a layman's book has to be out there, written by a former Alito clerk, as Mike Lee is, son of a solicitor general, son of the BYU Law School dean, son of the BYU president. Mike Lee is one of the Judiciary Committee's most thoughtful conservatives and constitutionalists and originalists. Thank you, Mike Lee. Don't go anywhere, America. I'm coming right back on this Wednesday edition of the Hugh Hewitt Show.